Hello, welcome to another video. Today I don't speak about a particular topic, but I'm excited because I had few questions and I'm going to answer those questions today. So it's not a specific topic, and I'll give answers, and these answers might also be useful to you. You might have had these questions as well, but you did not get the opportunity to ask me, but it will be helpful, I hope. The first question says, I cannot speak English well. Can I speak my home language at the CCMA? The answer to that is definitely. You will recall that when I was doing a video on the referral, and also there is a video where I speak of language, that you are encouraged to speak your language. The CCMA and the Bargaining Council will provide interpreters so that you are able to speak in the language that you are comfortable with. Do not put yourself under pressure and speak English, and it might also make it difficult for you if you don't understand the language or you cannot articulate yourself in that language. It makes it difficult for commissioners to get your story, and you might not even bring your dispute clearly. Because remember, a dispute and how you prove or you disprove your case is in details. So if you are limited in terms of vocabulary, it makes it difficult for the other person to even understand you. So by all means, use your language and advise the CCMA to provide an interpreter for you. Okay. The second one says, I once lodged a dispute at the CCMA. Within few days, I was called by someone from the CCMA, and she said she wants me to discuss the matter over the phone. Is it acceptable? The answer to that, yes, it is. What the CCMA would do would engage parties on a pre-conciliation process. This process is done as soon as we have referred to the matter, and it assists both parties to resolve the matter before it can be scheduled before a commissioner. So it's a pre-conciliation, but the outcome of it are similar to that of a conciliation. If it is unresolved, a certificate might be issued or it might be referred for conciliation. But if it is resolved, a certificate is issued indicating that the matter is resolved, and there would be a settlement which will be signed off by both parties and the one who was conciliating the matter, and that will rest the dispute. Yes, it is acceptable. The process is called pre-conciliation. So if you are called before you are invited to appear before the CCMA, know that that process is acceptable and it is official. Okay, the third one says, myself and 5 others would like to lodge a dispute at the CCMA. We were dismissed for the same misconduct. Should we open a dispute individually? It's not necessary for you to open or to file a dispute individually. If you worked for the same employer and the reason for termination was similar, you may open one dispute in one referral form. And remember, where I explain in the referral form that you can put your name and indicate that it is the number of others that are involved, and the names of those who are involved should be attached in that form, and the ID numbers and signatures should also be part of that addendum. Then it can be part of that dispute. There is no need to refer the matter under these circumstances individually. Okay, the next question, it says, I have been issued with a final written warning and I do not agree that I deserve it. Can I refer a dispute in relation to the warning? Yes, you can. You can refer a dispute in terms of unfair labor practice, where you dispute the disciplinary action of the employer. So you follow the process, you fill in the matter, and eventually you'll indicate why you think you do not deserve the final written warning. The commissioner at the end will make a decision after, of course, listening to both parties as to whether the final written warning should be set aside or not. And thank you very much for this question, because the thing is, some people would disagree with the disciplinary action being the warning that has been issued, and in few months that warning works against them if they are dismissed, and the employer relies on that to say you have been warned before, there was a standing warning against you, and that is why the dismissal is deemed to be appropriate at that time. And during the hearing at the CCMA of a dismissal, it's only then the person would say, but I was not happy with the warning that I was issued with. And at that time, it's a little bit late, because that warning had not been challenged to the CCMA or to the bargaining council, and at the time you were terminated, that warning might have been standing and valid at that time. So it is important also for employees who are unhappy with the outcome of a disciplinary hearing, or for whatever offense that they might have committed. If you are unhappy with the penalty that has been issued against you, you may challenge that, and the CCMA will make a decision whether it stands or it should be set aside, or a lesser sanction was appropriate, depending on your case, of course. So the answer is yes, you can refer the matter to the CCMA or the bargaining council. The next question says, I have been employed for 2 years and I have been dismissed for gross misconduct. Should I not be issued with a warning? The answer to this is yes. It can also be no. You see, there is no law that says you should be issued with a warning for the first offense, a written warning for the second one, the third one, a written warning again before the final written warning. There's nothing like that. But what people normally refer to is a progressive discipline, meaning you commit an offense, but the offense that you have committed might not attract a harsher sanction. So you might be issued with a warning. And also, you might have 5 years of experience or in the employ, and you might not have had any warning for anything. And the first offense that you commit attracts that penalty of a dismissal. What is important is that the offense that might have been committed should match the penalty. Okay, so an employee might have been late for work and there might have been a warning issued to them, but also the employee might be late for several times and there might have been warnings that have been issued to him or her and eventually dismissed. The other employee might commit a very serious misconduct, and on the first instance they might be dismissed. So it depends on the nature of the gravity of the offense and whether you should be met with a dismissal sanction. So it depends on the nature of the offense that you might have committed. So those were the questions that I had, and I hope it assists a lot of people in understanding how the labor law and labor-related matters when it comes to discipline and referring disputes works. Thank you very much for joining me. Bye-bye.